It's 7:30. Good evening. I'd like to call to order the March 26, 2026 Old Bridge Township Planning Board. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Daniel, could we please have a roll call? Here. Okay, we'll have the swearing in of the officers.
Thank you. This is for our board professionals. Will you please raise your right hand and repeat after me? Not repeat after me, sorry, wrong swearing in. Do you swear or affirm that the testimony you're going to give this evening is the truth, the whole truth, and nothing but the truth? I do. Thank you.
Okay, first order of business, minutes of February 26, 2026. Okay.
Mr. Palmer? Mr. Palmer? Yes. Ms. Gannon?
Yes.
Mr. Petty? Yes. Ms. Masella? Yes. Mr. McIsaac? Yes. Mr. Brennan? Yes. And Chairman Lau?
Yes. Okay, next, March 12, 2026 minutes.
Mr. Palmer? Yes. Mr. Palmer? Yes. Ms. Gannon?
Yes.
Mr. Petty? Yes. Chairman Lau?
Yes. Okay, resolutions, 65-2024P, Hook Mountain Associates LLC. Do I have a motion?
Mr. Palmer? Yes. Mr. Palmer? Yes. Ms. Gannon?
Yes.
Mr. Petty? Yes. Ms. Masella? Yes. Mr. McIsaac? Yes. Mr. Brennan? Yes. Chairman Lau?
Yes. Okay, the next resolution, 22-2025P, Matchaponic Estates LLC, Brookside Villa, denial. It's being moved.
Yes, Mr. Chairman, thank you. That resolution has not been prepared yet. We are still in discussions and having a meeting with the applicant's attorney and the township attorney, holding off on preparing that resolution at this time based upon the applicant's request. So that will probably be carried to, most likely, probably not until the May meeting, but I will advise the board when it's completed.
Okay, application 53-2024P, HB Warehouse LLC, major preliminary site plan with a C variance. Good evening.
Mr. Chairman. I'm going to read right now. Good evening, everybody. Thank you for your time this evening. Thank you for the new location. We know it's not that easy logistically to get this accomplished, and we do appreciate it.
Before you get started, I just want to let you know that testimony ends at 10 and the meeting's adjourned at 10:30.
Understood.
Okay? And if you could have your witnesses, if there's any acronyms that maybe people on the board or people in the audience aren't familiar with, have them say what they are.
Sir.
Okay, thank you.
So thank you for having us this evening. For the record, Larry Talley on behalf of the applicant. The applicant is HB Warehousing LLC. This evening, Mr. Chairman and members, shortly I'll frame what we hope to do here this evening, what we've already accomplished at the Board of Adjustment, and who you'll hear from this evening. But by way of brief introduction, I don't think we're going to be all that lengthy this evening, Mr. Chairman and members. We have a thorough report from the consolidation of your board professional staff the other day on the 24th. It raises some nuanced issues that were not part of the prior report, and the prudence of the applicant and the cadence of the applicant thus far has been to be incredibly thorough with reviewing and considering everything. So there are civil engineering items in there that we need to still review and perhaps even discuss with your board professionals offline. So that being said, the punchline is that you're only going to hear from two witnesses this evening. You're going to hear from our operations witness, Mr. Brian Danahy, who's a principal with Stonemont Financial Group, SFG, who's the joint venture partner of the applicant owner entity. Mr. Danahy will walk you through what they do by way of warehousing development. They are a very well-respected, long-time operator and developer of warehousing in the Northeast, including in New Jersey. They'll tell you what they hope to do here on this site, where the site is already approvable for a warehouse, if you will, by way of the use being permitted in the zone. And we'll go through some high-level operational issues with Mr. Danahy. We expect that to be very limited this evening. Not that much testimony on that since it's a permitted use of the zone. But we'll walk you through what you would see here day over day if this were approved. Then we'll have our project engineer, Mr. Josh Weary. Josh is the scrivener of record of the civil plans that are before the board from Dynamic Engineering. Offer some baseline introduction testimony. We're not going to get that far, like I said. We'll walk the folks through existing conditions, proposed conditions, what you're going to see by way of the programming on the proposed conditions, and then we'll probably leave it there for the evening. And we'll regroup. Mr. Weir will return at another public hearing. So if cross-examined is deferred for him, that would make sense because he will be coming back to continue testimony at the next public hearing, whether that be at a special or whether it be at, I know June was already assigned for continuation of this matter. And then we'll go from there. And at that point, Mr. Chairman and members, just to give you the full picture of the application, we'll move relatively expeditiously, but we'll answer all your questions. We'll make sure the public gets to say their piece and their inquiries are responded to. But our witness deck thereafter is going to be what you would typically expect to see on a planning board application. Our project architect will testify as to the elevations, the renderings, the limited floor plans, not much of a floor plan of the warehouse. We'll have, our traffic engineer testify for dynamic traffic. We submitted two versions of a traffic impact statement. The most recent one was an updated version submitted with the March resubmission from Dynamic. Our traffic engineer will testify on a limited basis as to the benefit of the results of that traffic impact statement. Our project planner will also testify, and at that point, we'll try and wrap it up. If there's anything open and lingering, we will go through it then with continued witness testimony, but we expect to move through this on our end relatively expeditiously and efficiently, Mr. Chairman and members. So with that, brief introduction to the project. I know the board knows this case very well. It's been sitting around for quite a while at the Township. For the record, it's 554 Waterworks Road. It's 3 lots, lots 9, 10, and 11. The lot number designations will be slightly adjusted in light of the recent zoning board of adjustment approval to modify the lot lines. The only thing accomplished there was really to jog lot lines and reconcile relics of existing conditions of the property. There was no development as part of that zoning board application that just concluded with an approval in January of this year. It just tweaked the lot lines slightly to adjust them. That preceded this application. We have the benefit of Mr. Sordillo and your board planner, your board engineers, thoughts on that had to occur first before we could prosecute the site plan case. That was prosecuted to conclusion successfully. Right now, it's still lots 9 and 10, 11 until the plat is filed and it'll be updated. So we'll just refer to those 3 lots for now, just for convenience sake. In block 6303. It's about 84 acres, just shy of 84 acres. We're in 2 zones. There's the SD3 zone that part of the property is in. And we're also in the Waterworks 2 redevelopment area. That's lots 9 and 10. Most of what we're going to be discussing for purposes of this application is on lot 9. That's going to be the situs of the warehouse that's being proposed. That's going to be where most of our discussion points are. Access will be up through the front lot because lot 9 is effectively a landlocked lot. There'll be an access easement to the street. But just about all the development that the board will be concerned with at a high level and a programming level will be on lot 9. And that's the warehouse, just under 520,000 square feet. The height will be compliant at 45 feet. There will be office space within that warehouse, and the end use remains to be determined. There are loading docks, there's driveway ramps, there's vehicle parking and trailer parking, but the end users are never really identified for warehousing or for outdoor storage sites until you typically have it approved. So that's the point when that would come into play. Again, before we go to Mr. Danahy as our first 2 witnesses tonight, the use is permitted. The redevelopment plan is relatively freshly minted. As this board knows, it's a few years old now. That plan would have come here before it was adopted. It would have come to this board for a consistency review after the area was designated an area needed redevelopment by way of non-condemnation. This board would have done a consistency review and recommendation with a referral back to the governing body. Thereafter, when the redevelopment plan was drafted, that redevelopment plan likewise would have come to this board for a jurisdictional peer review for consistency with the master plan and a recommendation prior to adoption of that RDP, the redevelopment plan, back at the governing body again. So this might feel like deja vu all over again to a few of the board members, because you've sort of seen this in one fashion or another when you saw the designation during the investigation and the redevelopment plan between its first and second reading and adoption. This is the culmination of that by way of this proposed application within the redevelopment plan area for a use that is permitted. All that said, Mr. Chairman, I think I've said enough, but even too much at this point. I will turn it over to our first witness to be sworn and introduced, unless you folks have any questions of me, whether procedural, technical, or otherwise.
No? Go ahead.
Sir.
Okay, I'm going to swear you in right now. Could you please raise your right hand? Do you swear or affirm the testimony you're going to give this evening is the truth, the whole truth, and nothing but the truth? Could you please state and spell your name for the record?
It's Brian Dandy, B-R-I-A-N-D-A-N-A-H-Y. So, as Larry said, thank you again for having us tonight. Appreciate the opportunity to present. A lot of time and effort has gone into this. And I'm going to start out, like Larry mentioned, just giving a background on Stonmont, who we are as a developer, how we've gotten to where we are today, our successes within the Northeast, specifically in New Jersey, and primarily in industrial development. So once I give you background there, I'll then transition into this project specifically, let you guys know a little bit of what we've done from a design standpoint, provide an overview, and then get into operational testimony. Stonmont as a firm is a real estate investment firm based out of Atlanta. We have offices in New Jersey, Mid-Atlantic, Southeast Florida, the Southwest, and the Midwest. We're a national firm. We've built tens of millions of square feet of industrial product throughout the United States with a lot of success, with several billion in assets under management. Of late, we've had a lot of great experiences in the Northeast. I'm the Vice President and Northeast Market Officer, so I lead our acquisitions and development for the tri-state area for Stonmont. With that, we have about a dozen developments across Pennsylvania, New Jersey, and New York. They span from central New Jersey, southern New Jersey, northern New Jersey, Staten Island, Long Island, central PA. And then we have a new development in Philadelphia that we closed on this week. The reason I give you the background is we've had a lot of great experience, and we've established a great team of professionals that have been able to help us throughout these developments. In the last few years, we've had a ton of success in New Jersey with developments in Somerset, and then most recently, great experience with the redevelopment program with the city of Passaic, where we built 300,000 square feet. We were recognized in the Development Magazine for our success there from the brownfield redevelopment standpoint. And so with that, we took our momentum here and partnered with HB Warehousing to put together the plan and the team that we have today. So as Larry mentioned, our team has been working on this for several years. We put together a team of design professionals and used our resources to establish our group that you will hear from later and provide testimony. That team put our plans together. We were deemed complete in March of last year. With that, we've been actively working with your township to implement the redevelopment plan that you put in place here. With that, we're excited for our plan that's in front of you today, as we feel that it meets the intent of the zoning that's been on this property for over 75 years, and the redevelopment plan is the guiding principle there, so we look forward to partnering with your township. So post-approval, our plan is to develop 520,000 square foot warehouse. With that, we will be building it to the new bulk standard for industrial. The goal in doing so is providing beneficial aesthetics from our warehouse, bringing an opportunity for us to, as Larry mentioned, have a speculative development that brings credit tenants to Old Bridge, which would provide potential of hundreds of jobs. With this, we expect to have a limited demand generator of waste and refuge. Since it's a speculative development, we're not entirely sure what the end user is at this point. They will comply with all municipal, county, state, and federal regulations applicable to acoustic emission and limitations. They would be working up to potentially 7 days with continuous hours potentially 3 shifts. And the approximate number of employees, as I mentioned, is unknown, but we expect that could be up to hundreds based off of the interest that we have thus far. Due to the way that we've designed this building, we've already received requests for information from tenants, and we expect to potentially have this building pre-leased, which would be great for Old Bridge and also for the project here. It'll allow us to then immediately get back to the community here. We additionally are planning on building solar on the rooftop of this building. With that, obviously there's general impacts to the area that are positive, and also potential positive impacts from an electricity standpoint as well. Outside of this, you will hear more from our design professionals that will identify more of the specifics on our deal. That cross-examination is welcome, and we look forward to all the specifics throughout these discussions. We really appreciate your time and consideration tonight. As you'll hear from our design professionals, this project has been well-planned, designed. We feel like we're the right team for the board to consider from an execution standpoint, and we align with the township's goals outlined in the redevelopment plan. So, thank you very much.
Brian, just one question. You mentioned that. Speak to the microphone. You mentioned, Brian, that you've approached this as sort of an aligned effort with the township, trying to marry it with the redevelopment plan. This wasn't the back of a napkin, George. This was years of the working, and the site's been like this for decades, namely industrial use on the front end of the site. During the application process, I think that Stonemont, and you, in fact, got on a plane to come up here for what was a gratuitous advanced neighborhood meeting that you offered to the public to meet your immediate neighbors, including the residents of the surrounding area, a meeting which you attended in order to explain what your proposal was and to address any concerns that they may have had as well. Is that right?
Yeah, that's correct. So our goal is, again, to be good members of the community. In doing so, we heard there was potential folks that wanted to hear more about our project. And so we hosted at a local restaurant an opportunity for the public to come speak to us. We felt like it was a good opportunity for folks to ask us questions about who we are, about development, any concerns that may come up through this process. Unfortunately, we didn't have a ton of turnout there, but we did offer that up in August of this past year.
Thank you, Brian. That's what we have, Mr. Chairman. Mr. Danny, we making available any questions? The microphone, please. We make Mr. Danny available to any questions the board members and the public may have at this time.
Okay.
Thank you.
Our professional. Vina, will you have?
No, I don't have any questions for her.
I don't have any questions either.
Okay, anybody on the board have a question? Okay, no, see no hands. Okay, we're going to open it up to the objecting attorneys first.
Mr. Chairman, so all we would ask is, as you folks know quite well, is that whoever the objecting counsel does represent is going to be precluded from asking direct questions and cross-examination of our witnesses and offering sworn statements. So we will need a list of the folks that are represented by counsel from the onset.
Yes, Mr. Chairman, and I apologize if I say your name wrong, Schorndorf? Schorndorf, thank you, sorry. Did provide me with the list, and I will share that with opposing counsel as well.
Okay.
Good evening, Mr. Chairman and members of the board. My name is Priscilla Schoendorf from Schoendorf Law, and I appear on behalf of my clients Anand Mehta of 61 Dahlia Lane of Old Bridge, New Jersey, Venkatadara, 41 Dahlia Lane, Old Bridge, New Jersey, and Vidit Jean of 29 Gazania Drive, Old Bridge. At the outset, and purely for purposes of preserving the record, I would like to briefly place an objection as to our request to secure an adjournment for today's hearing and address the procedural posture of this matter. My clients have been attentive to this application for some time and began seeking legal representation as early as December of 2025, particularly after the applicant was granted an emergent adjournment, at which point it became apparent that formal opposition and potentially opposing expert review may be necessary. For this March 26, 2026 hearing, I was only formally engaged on March 22nd, 2026. The following day, March 23rd, 2026, I submitted a request for a brief adjournment so that I could conduct a meaningful review of the application materials, prepare an informed response, and evaluate whether retention of appropriate experts would be warranted. I understand that the township advised that the applicant's consent was required for such an adjournment, and the request was thereafter referred to the applicant. An adjournment and consent were not provided. As a result, my clients and I have had only 3 days to prepare for a matter of the scale and complexity. I raise this not to assign fault, but simply to ensure that the record accurately reflects the limited time frame available for review and preparation, particularly where issues presented involve technical disciplines and potential long-term impacts upon approximately close interested parties. With that said, I appreciate the board's time and attention this evening, and I will proceed in a focused and respectful manner to assist the board in consideration of the application. I do not have any questions for this particular witness at this time. Thank you.
Thank you. Okay, I'm going to open it up to the public. And you have approximately three minutes to use up, and try to keep it at questions of this witness. Go ahead.
Yes, Mr. Chairman, just to make sure we keep it orderly and proceed as required by law, this portion is not for general comment. You will have an opportunity to provide general comment on the application, provide your own testimony, your own information, documentation, all of that, but that is not at this point. At this point in the application, it's just questions, and it's only questions from this witness and based on their testimony. You'll have opportunities to question all of the witnesses throughout this whole process, but right now, I just want to make sure we're all clear on the process. Right now, it's just questions on this witness and this the testimony they gave this evening.
Good evening.
And I apologize, just because we have a record keeper here taking a transcript. If you could please, just as I asked the witnesses do, if you could please state and spell your name, just to make it a little bit easier for the transcriber. Thank you.
My name is Hardik Bhatt, Hardik, last name Bhatt, I'm 45 Dahlia Lane. The applicant mentioned that they had provided us an opportunity to meet with them at a restaurant. How was that communicated? Because I wasn't aware that there was any meeting of any kind scheduled or requested.
Yeah, we mailed it, regular mail to every single person within the proximity, the exact proximity of.
It would have been the 200-foot radius list propounded by the assessor that would have been utilized for this initial gratuitous meeting, not the public hearing notice, but it was the assessor's list of everybody within 200 feet of property. They received a letter invited to a meeting, Mr. Danahy and company, to discuss the project. And I believe nobody attended, is that right, Brian?
Yeah, nobody attended.
I would like to put it on record that I am one of those people that are within the 200 feet notice, and I can attest to the fact that I never received such a letter. Thank you.
Thank you. Next.
My name is Bina Bhavsar, B-I-N-A, Bhavsar, B-H-A-V-S-A-R. I live at 25 Azania Drive. We did receive the notice, but it was 1 week late. By the time letter came, it was the date has already passed. And I believe some of our neighbors had the same thing, that just the letter was not received in time for us to attend the meeting. So we weren't given any opportunity to ask questions at that time. And that is the reason no one attended, because we did not get the letter. That's it.
Okay, thank you.
While we wait the next person to come up, Mr. Chairman, I'll just say that we have no withdrawal policy in my office. We always have. My name, my address, my phone number, my email, everything but my blood type is on my actual legal notice. Members of the public can call me anytime they would like. We could certainly put them in touch with ownership at Stonemark. We haven't heard any questions or comments. All we've heard was, folks looking to be intent upon this project not happening at all. But if they want a meaningful conversation, our doors are always open for off-record dialogue with members of the public. If they're represented by council, we will from council. But otherwise, that offer remains and stands. If they have questions, and they want to raise any issues, so.
Okay, thank you. Any other hands? Go ahead.
Hi everyone, my name is Sean. First I'd like to apologize about my appearance.
I'm so sorry.
Yeah, you guys hear me now? Yeah, I might cut off. Thanks. Hi everyone, my name is Sean, spelled S-C-A-N. First, I'd like to apologize for my appearance. These kind of meetings seems to get postponed quite often, so I just came from a workout. But to our witnesses, you guys look very sharp here. So just a simple question, a hypothetical question for our witnesses. How would it feel if, right in your backyard, there's a, hypothetically speaking, 24-hour operations, logistical operations. So that means like workers, trucks, heavy equipment operating all the time. How does that make you feel?
Mr. Sardillo, can we get a full name for Sean here and an address for the record, please?
Sure.
Well, we don't ask addresses anymore. Everything, most of my towns, we don't ask specific addresses, but full name, yes.
Yeah, I could give my full name. Sean Kim.
Thank you.
Do we ask whether or not there are residents of the municipality?
You could ask that question.
I'm just curious.
But we just don't, because of Daniel's law, we don't know who, they're part of it, we just avoid all addresses altogether.
Oh yeah, I'm absolutely a resident of this town. So I can't speak on your behalf. What I can say is, Vina presented a really, really beneficial slide and presentation at the zoning board. It illustrated the history of this property, and it's been zoned industrial, I think, Vina, correct me if I'm wrong, for 75 years. And so, when the residents were built behind, it actually required a variance for those residents to be able to pull permits to change out their decks or to do any modifications because this is an industrial area. So you guys asking these questions aren't necessarily applicable because it's zoned industrial. Your township is telling you through the redevelopment plan that that's what they intend on having here, and that's the intended use. And we are simply building a building per that intended use. I'm sorry, my question was simply your opinion, if this was built in your backyard. That was my opinion. Thank you. Very interesting.
Okay, thank you. Any other speakers? Okay, I close the public session. You get your next witness.
Thank you, Mr. Chairman. Josh Weary, our project engineer, Mr. Chairman and members.
Good evening, everybody.
All right, would you please raise your right hand? Do you swear or affirm the testimony you're going to give this evening is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please state and spell your name for the record.
Sure. So my name is Joshua Weary, last name W-I-R-R-Y.
Josh, for the record, the benefit of your qualifications, background, and licensing, if you would.
Sure, no problem. So I'm a licensed professional engineer in the state of New Jersey. I graduated from New Jersey Institute of Technology with a Bachelor's of Science in Civil Engineering. I'm a principal at Dynamic Engineering located in Chester, New Jersey. Testified before various boards throughout New Jersey, including the Oak Ridge CPA. I have over 10 years of design experience.
You're accepted.
Thank you, sir.
So, Josh, I'm only screaming so I don't get yelled at for not being the microphone back there.
Yeah. All right.
Josh, we're going to be relatively limited this evening with your direct, as I indicated to the board during my proffer. We've got the benefit of an extensive board report. We want to work through it cohesively and with the board professionals. We know we can. That's not going to happen this evening on the battlefield, so to speak. So what we will do this evening is relatively limited. I think you're going to show and orient the board with existing conditions of the property, which have been there since decades ago, as Mr. Danny even alluded to during his direct testimony, and then the high-level proposed conditions. And I think, Mr. Chairman and members, we're going to introduce two exhibits this evening both of which we advanced already in PDF. We will mark them this evening when we get to them. We'll pass around. And we're going to pass on the exhibits to two simple sheets, existing and proposed. It's really a site plan rendering used to orient the board with the site plan detail and color. Mr. Weir will walk you folks all through that right now, and I'll turn it back over to Josh.
And what are we going to be marking these as?
Exhibit A1 will be an aerial prepared by Dynamic Engineering.
Yeah, so our first exhibit is entitled Aerial Map Exhibit, which Mr. Kelly mentioned we marked as A1 for the record. Is dated with today's date, March 26, 2026, at a scale of 1 inch equals 200 feet, and north is to the top right corner of the page.
And can we also just make sure the objective strings has a copy of this? And the other exhibit will be A2, or which one was that? Might as well just mark them now.
Is entitled Overall Site Plan Rendering, which we can mark as A2 for the record. Again, dated with today's date, March 26, 2026, at a scale of 1 inch equals 100 feet, and again, north is to the top right corner of the page. So if everyone has a copy of the exhibit, we can get going with A1. So this is an aerial image of the surrounding area with the properties outlined in yellow. The site is located along Waterworks Road as depicted at the top of the exhibit, and the property consists of 3 lots within block 6303. So starting with the proposed lot 10.11, it's approximately 24.13 acres, again located along Waterworks Road, and it contains the remains of the former CPS chemical facility, which is a designated Superfund site. And as such, the property is currently undergoing remediation efforts by the EPA, who formalized their cleanup plan back in September of 2019. Wetlands are also present in the eastern undeveloped portions of the property, and the Tennant Rush tributary, which is that highlighted blue line, runs along the southern property line and continues through the adjacent lot 11.11 to the west. So this specific property is located within the Waterworks Road 2 redevelopment area that was adopted back in June of 2023. Moving down on the exhibit, we'll go to proposed lot 9.11, which is approximately 43.54 acres. This is the largest of the 3 lots to the south, and the lot is primarily wooded, as you can see, and includes a wetlands area in the southwest corner of the property. This property is also located within the Waterworks Road 2 redevelopment area, and this serves as the primary location for the proposed warehouse facility that Mr. Kelly mentioned earlier. And then lastly, we'll move on to lot 11.11. This property is approximately 15.74 acres, again located along Waterworks Road, and includes the Old Ridge Minerals facility that is also included in a Superfund site and has ongoing remediation of the property to remove soil contamination. Lot 11.11 is located within the Special Development 3, or the SD3 zone, and wanted to clarify that no site improvements or expansions are proposed for the existing Old Ridge Minerals facility. However, there is a portion of the proposed access to be utilized by the warehouse facility that will extend onto their property via a proposed easement. So overall, for reference, the entire site, including all 3 properties, is approximately 83.41 acres. And as for its topography, lot 10.11 is relatively flat and ultimately drains south towards the Tennant Brook tributary, whereas lot 9.11 in the rear generally slopes down from east downward to west towards the existing wetlands in that southwest corner. And just for reference, there's approximately 20 feet of grade differential across that site. And then lastly, as for surrounding uses, to the north and northeast, as you can see, are mostly industrial and commercial uses along Waterworks Road. To the west is the Perth Amboy Runyon watershed, and then to the south and the southeast are the residential parks.
Mr. Kelly, I believe that wraps up the overview of the existing conditions and the zoning for the properties.
Yes, sir. We're going to continue, Mr. Chairman. I don't know what the preference of the board will be, but since Mr. Weir will certainly be returning, we're going to go over, like we said, high level of the programming of the site plan conditions now. Much of that touches on report items, but at a high level, we want to orient the board with the layout, the structure, show you the loop, show you the circulation plan, where we're parking trailers, where we're parking cars, the structure, the access in and out. On that secondary exhibit that was passed out, we marked as A2. I don't know if the board's pleasure will be to defer cross-examination at that point, since we will be coming back, Mr. Weir, but we do now intend to go into the territory of the proposed conditions, Mr. Sordillo, so whatever your preference is.
Well, I think it makes more sense because of the fact that while you might be testimony to certain site plan layouts, certain things at this point, after your meeting and further review of the planning board's professionals' reports, that may somewhat alter, change. We don't know at this point. So it would be I think after discussion with the chairman, I think it's the board's preference that we would have cross-examination after the conclusion of the testimony, because that would make more sense rather than have cross-examination on items that may change or might not be the final product. So I think that's what the intention of the board, Mr. Chairman, correct me if I'm wrong, is that we would allow you to continue to do testimony of your engineer, but knowing he will be returning, he will be continuing his testimony and supplementing or altering anything they might be saying today based on the meetings with the board's professionals. And then when his conclusion is at the next hearing, then that will be open to the cross-examination from the objector's attorneys and anyone from the public as well, to all of his testimony.
Yeah, I think that makes the most sense. I don't want to presume. Absent Mr. Weary hitting the Powerball and the Mega Millions, I think you'll see him back at the next meeting, Mr. Chairman. So the odds are pretty good you're going to see him again.
Okay, so we can move on to the Exhibit A2 for the record. Give the board and the public a high-level summary and overview of the development as it stands today. So this exhibit that's up on the screen here is a rendered version of the site plan that was submitted, and the applicant proposes to construct a 518,542 square foot warehouse facility, which is a permitted use within the redevelopment plan. And the building is depicted as the orange rectangle on the exhibit you see. The building also includes approximately 19,286 square feet of office space, which will be located on the south side of the building, or the bottom side of the page. And the building is orientated so that the proposed loading docks are located along the north side of the building. And that was done purposely so that the loading operations are, one, located away from the parking areas, but also located away from the residents to the south of the property. The building area will comply with the township's floor area ratio requirements, whereas 0.3 is permitted and 0.273 is proposed. And the building height, as Mr. Kelly mentioned, complies with the maximum building height requirement, whereas 45 feet is permitted and 45 feet is proposed. And to give a brief summary as to access and circulation, we are proposing a new full movement driveway along Waterworks Road, which will be utilized by passenger cars as well as trucks to access the warehouse facility. And a 35-foot wide access will be provided through lot 10.11 via a proposed easement. Now, as you move into the warehouse facility, we are proposing 40-foot wide access aisles for two-way movements to allow trucks to access the loading areas along the north side of the building, and a 30-foot wide loop road is proposed around all sides of the building to allow passenger vehicles to access the parking areas along the south side of the building and to allow for full circulation around the site. And I wanted to point out that the access road was reduced from 40 feet to 30 feet in those areas, as trucks are not intended to circulate around the south side of the building, but they do have the ability to do so if they were to make a wrong turn. Sticking with the southern parking area, we are proposing 24-foot wide drive aisles for two-way movements. and that parking area includes 379 physical parking spaces, which complies with the redevelopment plan, whereas a minimum of 260 spaces are required and 519 spaces are permitted. So we are actually 140 spaces less than that maximum threshold. The parking area also includes 9 ADA spaces as well as 18 make-ready EV charging spaces, and the building also includes 86 loading docks as well as 2 driving ramps located along the north side of the building or on the top side of the page. That will also comply with the redevelopment plan, whereas a minimum of 17 loading spaces are required and a maximum of 130 loading spaces are permitted. So we are actually 44 spaces less than that maximum threshold. The proposed loading spaces will be 13 feet wide and 60 feet in length, which complies with the township's requirements as well as industry standards. And then just north of the loading docks, we are proposing 57 trailer storage spaces, which will not be utilized for loading and unloading. They're simply utilized for trailer storage. And Mr. Cali, again, this is a high-level summary and overview of the proposed development. Our office did just receive the Township's professional review memo, which we're working with the applicant to review in detail. And again, before we get into the details of our design, we plan to address and respond to those items ahead of the next scheduled meeting.
Mr. Chairman, members, that's effectively all we have this evening. You know, we wish we could present more, given the benefit of the 2 hours to go, and the fact that we've been lying in wait for quite some time to start prosecuting this case. As your professional staff know, I email them almost daily. I think we're all going to have Thanksgiving dinner together next year. I mean, it's nonstop. We want to get in this room. We want to prosecute this case before this board. But the applicant is not bullish. The applicant is a very savvy developer and operator of these facilities. They want to work with the township. You know, a true testament to the fact that we're within the redevelopment plan area. We are a conforming site plan. The deviations are hyper-technical. We see a staff report that we want to review, prudently respond to, and thoroughly respond to. So at this point, we don't think it's really wise to continue with our witness deck this evening, although we certainly could have kept barreling forward with other witnesses and tabled Mr. Weary for now. We think at this time it's sort of a natural concluding point for this evening. We do think that we can conclude our direct case in chief at the next public meeting, given the limited witnesses that we intend to present. Our planning proofs are going to be relatively limited. That should be limited testimony. Traffic might be pretty limited. It's a permitted use, so traffic has already been factored in theoretically to the redevelopment plan, so that should just be the belt and suspenders of our witness. Mr. Weir will continue. Hopefully a lot of the items of the staff report have been reconciled by then. And with the architecture, I think you're going to see a nice structure. You're not going to see the box of the 1960s and 70s warehouse. It's a very nice, well-articulated structure. I think you're going to be impressed with what you see from our project architect. We're going to try to keep it moving as efficiently as we can. Mr. Chairman and members, we think we can do that at the next meeting. We are still hopeful that there might be a chance for a special between now and the end of June. I will work with the staff on whether or not there are dates that the board members will be ready, willing, and able to hear the case, and whether there's venue space available. But that will still be a request likely of the applicant to try and proceed a special between now and the next meeting.
Mr. If I'm correct, the next meeting that this is scheduled for, if there is no special meeting, is the June 25th, 2026 meeting. Is that planning on being here again, or is that going to be at the? Okay, because I want to make the announcement to the public. That's why I wanted to make sure. So the intention at this point is that the meeting is going to be in this room. So for all the members of the public and objector's attorney, please be advised that the applicant is concluding his testimony at this time. It's not complete, so you will have an opportunity to fully question this witness. Everyone will have their opportunity to provide cross-examination and questions of the witness. It's just we're going to wait until his testimony is completed. As you heard, there really wasn't much of a testimony from the engineer this evening. It really was just top line looking at what was is being proposed, but they have to look at the board's professionals' report and address those concerns. So what you're going to see in testimony will be the final version that you'll really want to question and get your comments to. Please note that if there is any material changes to the plans, they will be submitted at least 10 days prior to the hearing so that you'll have an opportunity to review those as well. The applicant has been very working with the board, so if we can get them earlier, we'll provide them earlier, but that's the minimum is the 10 days prior, so you will have an opportunity to review if there are any material changes. But I just wanted to make sure that everyone here is aware that you're not being ignored. You will have your opportunity to question this witness. It's just going to be when they complete. And right now, you're all being put on notice, and anyone watching, that hearing is going to be for continuing on June 25th, 2026, 7:30 in this room. There'll be no further notice provided. If there is a special meeting that does get scheduled, it works out that we will proceed on a different date, you will be provided the 200-foot notice. There will be new notices posted in the newspaper. That is required by law. So if there is a new date, you know, the special meeting, you'll get notice. There'll be the required notice that the board has to put forward for a special meeting, and you'll have the specific land use notice as provided by the applicant as well. But if you don't receive new notice, and please feel free to reach out to the the board at any time to just confirm at any that it hasn't been changed. But if you don't get notice, this hearing is going to be continue on June 25th, 2026, 7:30 in this room without further notice.
Thank you.
I just want to thank you again, folks, for your time this evening. Your professional staff has been fantastic to work with. We really appreciate their effort. And I was going to apologize for talking fast, but I think Joe beat me, so if anything, I got to set my game up, Joe. That was good. Anyway, we thank you folks for your time. We look forward to continuing this and hopefully concluding the next public meeting, whether it be a special or the June term, Mr. Chair and members.
All right, we'll see you June 25th. Thank you. Okay, now we're going to open it up to general public comments, but not about this application.
It's just if there's any general comments that anyone in the public has relating to anything under the planning board's jurisdiction, we have a general public comment period at the end, but it can't be regarding a specific application. That is during the special public comment periods that you'll be provided during this hearing at the June date.
Okay. Yes, sir.
My name is Ankit Modi, and I don't have a question regarding this application, but I have a question regarding the planning board and the engineering team. Is there any way they can include us, in this collaboration, and we can ask them a question directly instead of waiting for the, general public comment? As a community, we have been trying to reach out to you for a long period to, set up a quick call or set up a meeting, just to go over the, some of the key points. And we got a negative feedback. So just want to hear it out. If you can, involve us in this conversation.
So I know the administration was trying to schedule a meeting with myself, the council chairman, the business administrator. There were some hiccups because of vacations and emergencies. So I'm going to pursue that because I did follow up this morning with the administration to see where we were, because I'll be happy to answer any questions which the residents may have at that point. But I have to go through the administration. I'll reach out to them again because the township attorney was also going to be a part of the meeting, and our schedules have been a little off. But I'm pretty certain before the next public hearing, you will have a chance to speak.
Thank you so much. I understand everyone is busy, as we are also busy, and we have been trying to do this communication since last 3 months. So I hope we can, do it sooner.
And in the interim, I know Mr. Cali said that the applicant had tried to reach out to the residents, and I know there was a meeting scheduled. I heard about it, but I also heard there was no show. So I would just recommend, since we have 2-3 months before the next hearing, maybe you reach out to the residents one more time to see if they have any direct questions that you want to answer.
At any time. Now we only have a questions for the planning board. Now we don't want to reach out to them.
Sure.
So again, just to give you the answer, there are approximately 40 residents in that 200 feet radius, and none of them received any invite in a timely manner. So this is the one reason we don't want to reach out to them. But I hope we can, set up some communication sooner or our community discussion. Thank you.
Sorry, I don't think you saw it because it's behind the.
Oh, go ahead.
HARDIK, I have a question regarding the application process that the board follows. If an application has been deemed complete at a particular date and the applicant continues to resubmit and re-update their plans, how can that application be considered complete?
Mr. Chairman, may I answer that? The completeness review is making sure that they meet
All of the checklist that's part of the application process. If you go online in the township ordinances, there's a checklist in connection with certain applications that have to meet. What happens is when the applicant submits an application, the boards administratively through the planning department reviews that application and will go back and say, you're missing this item, you're missing that item, you're missing this item. If they then come in and you can either provide it or they can ask a waiver. And then if they have to ask a waiver, meaning can I not have to produce that document and this is the reason why, then it's up to administration to say, yes, we agree for this application you don't need to submit this document or that document because of the reasons that you've requested or put forth. At that point, if they met all of the checklists and been granting a waiver for all the items that aren't on the checklist, they're deemed complete. Now, that doesn't mean that during the process, after it's deemed complete, and when they start receiving boards reports and township reports and reviewing it, or, even starting applications and starting hearing them before the planning board, that they may get feedback where they say, or even a lot of times it even comes from the residents. They get feedback and hear that, this is, the residents don't like this. The neighboring property owners would prefer if you moved a retaining wall or you added some additional landscaping. So what would happen is the applicant, when you have a good applicant who's listening to the public and listening to the board, they'll revise those plans. And then they'll come back before the board with the revised plans that have those changes. And then at that point, by law, they have to submit them to the board at least 10 days before so that we can give them out to the public and the public can be able to see them before the next hearing. And then they proceed on their amended, plans. So that's why, even though it's deemed complete, sometimes they do change and modify some of the submissions because either it's at the direction of the board's professionals, at directions of the planning board, or maybe even just listening to some of the public comments and questions that come in. Because I can say just recently we approved an application within probably 3 or 4 months from now that the applicant made substantial changes to their application based upon concerns that they heard and met with the residents. So it does happen. Not saying that this one will or anything else will change because we can't talk about a specific application, but in general it does happen and that's why those things change. You're welcome.
Okay. Go ahead.
Hello, good evening. My name is Pedro Amaral, Pedro, last name Amaral. Just a general question for the board. I don't know if this applies to this board, but how in this township can we guarantee that if there's a construction near a Superfund, there are no contaminants in the air that will affect residents living nearby?
When we review the application, we do ask those questions to the applicant, and it's the onus is on the applicant to testify and provide that information to not only just us, but the board, and you will hear it too.
And in general, when you have a Superfund site or any kind of cleanup, even if it's not a Superfund site, the party that's responsible for that cleanup or remediation is required to actually notice the township. So there's notices for that stuff that are on the record, and they also notify property owners within the area. Now, in certain cases, a subdivision is actually built adjacent to a Superfund site. That developer also prepares environmental studies, which are submitted to the board for review. They get reviewed by the board's professionals, and they're also a separate process where they hire environmental professionals who are licensed to do the remediation, and there are reporting requirements for those professionals as well. And all of these things require noticing to the township and to adjoining properties, and those notices are kept on file. So if you ever have questions about that kind of stuff, you can contact the township clerk's office, and they have notices for those kind of things on file as well.
Also, just like we are responsible for zoning or development applications that occur in the town, right? When there is a Superfund site, typically it used to be NJDEP, but now with this site, EPA is involved. So they are the ones who are actually, it's an agency that is monitoring it and reviewing it and will come up with a remediation process and strategies as well. So when they make a decision, there was a public hearing, I believe, that was conducted by EPA in 2018 to inform the public about what's going on with the Superfund site. And from what I understand, by the end of the year, they will be coming up with their final decision on what actually are the strategies for remediating that area. I know there have been monitoring wells that they have been monitoring as well. Because this Superfund site, I think, was first noted almost like 35 years ago. And at that time, it was DEP who was involved, NJDEP. Later on, it was taken up in the 1990s by EPA. So there has been extensive research and extensive work. If you go to EPA's site, you will be able to see a lot of material on the CPS Madison Superfund site as well.
One last thing, I know you're going to ask a question. When a development, because a lot of those timelines you hear from the 80s and 90s and 2018, and then you have a subdivision that's built 4 or 5 years ago. When a subdivision is built adjacent to even whether it's a Superfund sites are administered by the EPA, or it's a remediation site, which in New Jersey would be administered by a licensed site remediation professional under DEP supervision. Regardless of that, when there's a remediation site adjacent to a development, as part of the planning board process, this board and every board in the state requires that developer, for residential developments usually, we require that developer to do a point of sale disclosure that actually provides some disclosure to their buyers about the existence of off-site conditions. So that's usually how the notification process works. The actual, anybody that's interested in buying a property usually contacts, the record keeper for the township, which would be the clerk, to find out about that area. And then also, once they get engaged by the seller of a property, that developer also has a point of sale disclosure that they give to the buyers as well.
Thank you. A follow-up question. So it's fine that the buyer is probably aware of a Superfund nearby, but if there's any construction happening adjacent to the Superfund, right, that's work that's going on that might release some contaminants in there that might affect what is already there. It's different than a Superfund that it's still no one is touching it, or the adjacent properties, but when there's active construction, there might be some implications, right? Is there any active testing that we are guaranteed that when we are building, it doesn't contaminate or releases some agents in the air that could affect residents nearby? That was my question.
Yes, we can't speak about specific applications, so I'll speak in general terms. In generally speaking, if there is that kind of a concern, again, that application has environmental studies that they do, a preliminary site assessment, and testing that has to get done, and environmental impact statements that they have to prepare for large-scale applications. And those studies usually reveal what the impacts of that development are going to be on, let's say, if there's a remediation property nearby. And if that's the case, then there's measures that are put in place, engineering controls that are put in place to protect that cleanup site, and that also gets done under the supervision of a licensed site remediation professional or whoever the person is that's in charge of that remediation site. So
you know, if work is getting done adjacent to a cleanup site, there has to be necessary communication between those parties to ensure that you don't have an adverse impact on that cleanup site.
Okay, thank you.
You're welcome.
Seeing no more hands, I close the public session. Oh, sorry. You were hidden.
How are you? I just had a quick question. My name is Kiara. I'm a special education teacher and an administrative assistant at my local district. I've worked with a variety of population of children and adults over the past 18 years with special needs. A lot of people in our community, children, adults, babies, they have challenges with loud noise exposure, sensitivities to particular smells, physical reactions to changes in the environment that pose an extreme health and overall well-being risk. A lot of us moved to Old Bridge because it's a beautiful township that offers a little country-esque life. And speaking in no particular application, we just want to know collectively, why was a residential zone approved upon industrial land when the intent was to expand further? And why are we all put in this position to now figure out where we're going to exist and live?
That's a good question.
Thank you.
I mean, I don't know if this body, the planning board, really has the ability to answer that, because this body doesn't establish zones. I mean, we review for consistency when a zoning ordinance gets adopted or a redevelopment plan gets adopted or presented. This body reviews it for consistency with the master plan, but this body isn't the one that adopts that or establishes those zones. So I don't think this is the body that can really answer that question. Though reaching out to administration, that might be a better, you know, and attending that type of meeting might be a place where you can get that answer a little bit better.
Thank you. We had reached out and spoke to the zoning board, and they said to ask you guys, so we'll reach out to administration.
Yeah, it would be definitely would be the zoning board.
This is a closer to be able to answer, but it's still not the right. Yeah.
Okay, thank you.
Okay, step up.
Hi, good evening. Just a quick question. If you zoom out quickly on Google Maps of the area, it seems like Old Bridge is getting very warehouse happy in the sense. If you go down 9 just a little bit further past Jake Brown Road, there's a warehouse back there. There's one diagonal to ShopRite and Target and all those things across 9. Now there's a huge development right across from ball fields, where all the kids are going to be playing right off Schulmeister Road, right? Is that going to be a warehouse too? We're not sure what that's going to be. I don't think anybody's really been told. I don't know if anybody knows. It just looks like there's a lot going on there. And now they're going to be putting one back there. It just seems like there's a lot happening around a residential neighborhood that was approved. And it seems like that was approved prior to the residential neighborhood. So I just need some clarity of what's going on here. You know, are we just looking for, you know, is it more tax income? Like, what are we trying to do?
The site adjacent to the ball field is a strip mall along Route 9 and a Toyota dealership.
Okay.
That's where you see a lot of work out there.
Okay. And just to reiterate, there are 2 other warehouses in the neighborhood already.
Yeah.
And it just seems like, you know, we find a space, we put a warehouse there.
Well, once again, this body doesn't set the policies
or the zoning. We hear applications that are subject to the zoning, but some of the points you're raising are appropriate when we get back before the public hearing on that application, because you're kind of teetering on that, but I think the points you're trying to make will be better served when we hear the public comments on that application, because I think that's something that the borough board will be able to hear at that point.
I understand. Yeah, we're just, you know, we want to know what's going on. It seems like every time we get pushed and pushed and pushed, zoning, throws us this way, and this is getting pushed. We all came here prepared to speak tonight, and now it's not happening, so everybody's a little frustrated. We just kind of want to, get our gripes out. Hey, this is our backyard. I'm sure if it was your backyard, you'd be right here with us, right? So, help.
Okay, thank you.
Hi, good evening. Hi, this is really tall. So, this is like my second time to attend the meeting. The first was a zoning and now it's a planning. Whenever we ask, we're always told, oh, your question is meant for the planning board. And then now when we ask, we're told that the question is meant for like another department. So before that, I decided to just go on the website and check. And it says here, the Old Bridge Township Planning Board's primary responsibility is to guide and regulate land use and development in a way that protects the public health, safety, and general welfare of its residents. And this includes assessing things like traffic impact, environmental concerns, drainage, and neighborhood compatibility. Given that over 250 residents, us, have expressed concern about the warehouse impact on our lives, traffic, safety, and the quality of our life and health, and plus even the property rates would even go down because of that.
I don't want to interrupt you, but you're talking about
this specific application. These are what your comment is very important, and I think you need to make it to the board. But the board can only consider it as part of the
How
application.
does the board reconcile approving the application and its obligation to protect the public's health, safety, and welfare? And how can we be assured that you have our best interests as our planning board?
Well, that's what this board does
is look at each individual application, not this, we're not talking about any specific, but every application that comes to this board, we look at that in conjunction with the board, the township's ordinances. So there are, while what you read is 100% correct, but it's within limitations, and limitations are what the township ordinances say. So if a township ordinance says that it can be developed a certain way, this board cannot deny that unless there's another reason to do so. It must violate a different, meaning they need a variance, they need some other exception to the rules. If they're compliant with all of the rules, the board can't just simply deny it because the neighbors don't want it on any application. Because if they do so, it will go to the court, and the court will just overrule the board.
But that goes against the very reason why the board exists.
No, the board exists to enforce the township's ordinances while taking into account. It still has to operate within the boundary of the law, and the township's ordinances are applicable law for the township. So we can't just require something that the ordinances don't require. So we are limited in that area. But if they're asking for, so you can aware, if any applicant is asking for exceptions, meaning variance relief, then this board can say, well, wait a second. If you're looking to get an exception from what the ordinances require, well, now we don't like what you're doing here. You have to change it. We don't like what you're doing here. We have to change it. Or potentially deny the application altogether. So it's just a matter of whether or not they're looking for exceptions, which certain applications are, and we can't talk about specific applications right now. But as you might notice, most of these applications do come with a variance, and that's what gives this board's discretion.
We just want to make sure that you also think about our best interests, human level, doing what is right, lives over profit. That's all. Thank you.
Thank you. Yes, sir.
Hi, my name is Vijay. I just have a question for the board. We know this application and many other applications, these are all warehouse companies, they have deep pockets. They keep asking us to come back again and again. And how many times are we going to keep postponing or giving them time to come back? Because as residents, there's few of us being represented by an attorney. We don't have those deep pockets. So we'd like to understand from the planning board what's the limit that they have in terms of requesting to keep moving the meeting.
There's
technically no limit. There are land use applications that I've been involved in that span over years, and 12, 15 hearings. So there just legally there's no limit. This board has been very adamant of moving applications, making sure they're succinct, making sure they're presented well. The administration and the board's professionals vet these applications extensively before they even make their applications. So we try our best to avoid these type of things, but ultimately it's the applicant's application, not the board's, not the public's, the applicant. So if they feel that, if they make notice and say we're going to have a meeting this date and they don't feel they're ready, they have the right to say we want to adjourn it, we want to put it off to another date because we want to come back. Now, they might not have the date they want, as you could hear from some applicants, they are asking for special meetings. We can't accommodate them. The only availability of the board is months away. But that's, if they're going to ask for an adjournment, that's what they have to deal with. But they have the rights, their application. It's, the only obligations of the board is that we have to act in a minimum amount of time unless the applicant agrees. If the applicant doesn't agree and the board doesn't hear the application before those deadlines, which are, depending on the type of application, you're talking 90 days, 100, whatever it may be, then it's used up all the batteries. Sorry, I talked too much. No, but I want to answer your question. So there are time limitations, but those are really placed on the board, not the applicant. If the applicant keeps on asking for adjournments and consenting to a consent, then they're allowed to do so. There are limited circumstances where, by law, we can say, you're not prosecuting the application, meaning they're just adjourning it and they're not prosecuting, and then at that point, the board can say either you have to proceed or it's going to be deemed denied, and then you have to refile your application, refile your fees, if you ever want to proceed again. Those are denied without prejudice, meaning they can apply again. By law, we can do that at some point, but they have to reach the point that they're actually not prosecuting. If they're meeting with professionals, if they're making revisions, they're trying to adjust their application to meet the concerns by the board, then they have the ability to keep doing that. And it's unfortunate for objectors, because I can tell you as an attorney, latest attorney, I represented applicants, I represent board, and I've represented objectors, and I've been all over, and I understand the different, here we go, the different, viewpoints of it, and I can see how it could be frustrated, but unfortunately, we still have to operate because whether this board grants or denies an application, it has to follow the law to be able to make sure that approval or denial is upheld by a court or any appeal.
One follow-up question to that. So you mentioned that the applicant has the opportunity to adjourn or move a meeting. So if that's the case, the attorney here who's representing some of the residents requested the same. Why was that denied?
Because it's, like I said, it's the applicant's
Application, not the objectors or the public. It's or the boards. It's the applicant. So they have the control over the application, subject to the boards. Now, as a board attorney, like I said, I've been all over. We try to accommodate, requests from objectors' attorneys as well. In this instance, we could, as you can see, a lot of time and effort was made to put into this room. There's a lot of money that was spent on the applicant side and as well. So we couldn't just do it without the applicant's consent on this particular instance. I have, as a board attorney, representing the board, which is representing the public, if it is reasonable and the applicant's not willing, I will push for it, and I will try to make sure that we accommodate all parties, including, representatives of the public but in certain circumstances, it just, couldn't have been done at that point. But as we see, it was a very limited application, so I'm happy that the applicants or the objector's attorney will now have an opportunity to review it and have that time before, we get into really the meat of any application.
Step right up.
So I have a general question in terms of zoning. Now, this warehouse is on permitted use. Let's say down the line, or better question, is that zone frozen until the application
applicant's application is completed, or can a council change that zone? That
In New Jersey, what was adopted recently is the time of application rule. It used to be what's called the time of decision rule, meaning a municipality can change the zoning of any property at any point during a pending application, and that until an approval was granted, the applicant didn't have any rights or interest in the underlying zoning. The New Jersey law, the Supreme Court changed that, I guess maybe 15, 20 years ago. Don't quote me on the number of years, but it's been quite some time, where now it's called the time of application rule. So once an applicant files their application, they're entitled to whatever zoning's in place at that time, and a municipality can't change the zoning while that application's pending. They are vested rights in the zoning that's in place at the time the application was filed.
So the pending application, the applicant can continue to delay forever, is what you're saying, until the point where they can push this forward? Is that what you're saying?
No, not forever. They still have to prosecute, meaning they have to proceed with the application. They can't just sit on it and keep delaying and not doing anything. If they're making adjustments, if they're submitting revisions, they're meeting with board professionals, but they have to keep on adjourning for those reasons, they're still prosecuting the application. If you have an applicant who files an application and then just you don't hear from them, they get a hearing date, they request for an adjournment. They don't hear from them. They don't meet with the board. They don't meet with the board's professionals. And then they ask for another adjournment. After about a year of that, a board has the right to say, you're not prosecuting the application. It's now deemed denied without prejudice. You know, it's no longer pending. You'd have to refile if you want to proceed with it.
So I saw on the agenda that the applicant's completeness date was on March of last year.
Now we're talking about a specific application.
We'll talk about that.
So, in general, does the applicant only have a year to?
No, it's a reasonable standard.
That's just it. You know, a rule of thumb, I would say, and usually that's what I look at is about a year without. But it could be less. It could be more. It depends on the circumstances.
Is there a limitation beyond the year?
The year
Which is something I put forth because it's what I consider. You know, but it's no legal deadline.
Thank you.
Hello again, just another general question. This neighborhood that we all live in, every home, if you could even look Google Map or just look at the map back there. All of the homes that butt up against the industrial zoning area, or
I'm sorry to stop you, but this is really getting close to talking about the application.
I'm not talking about the application. I'm talking about the zoning area.
But let me just stop you for one reason is.
This board won't be able to consider anything you say like this when considering the application. And I think it's more importantly, and I'm saying this to your benefit, that you hold off on these type of comments. I know we're kind of dancing around talking about the application.
This is actually about our properties. My question was really about our properties.
But it may be beneficial for you to make
the same comment during the public hearing on this application, because it may be more influential and it's something the board can consider at that point. I know you're not talking about the applicant, you're going to just talk about your properties, but I have a feeling, and this is just suggestion, that instead of we dance, right now we're kind of dancing around, we hold off what these public comments are and make them on June, because then this board can consider them, this board can utilize them if they want to in connection with the application. We just, rather than just, you're more than welcome to continue, but it's my recommendation so that then it becomes more impactful.
Could I do it both times?
We try to avoid duplication here, so we're not.
Right. I just want to make it known, every one of these homes has a conservation easement behind them, right? Their backyards are cut. Their property, it's on their property. Conservation easement, they lose space in their backyards that they pay taxes on. There's an industrial area behind them. Why are the homeowners' homes cut with an easement for land that they cannot use but they own and pay taxes on? But the industrial area where people don't spend their whole lives and sleep there, gets that spacing between. Do you kind of get where I'm going with that? You understand? I'm just trying to make a point. Everybody paid for land when they bought a house. It's part of it is an easement. They lose that land on their property that they pay taxes on. There's an industrial space behind them that easement cuts off right there. So why are the homeowners being punished, for lack of a better word, for land that they cannot use, when there's an industrial space behind it that won't even use that land?
This would be a perfect comment at the.
And I will.
I'm just saying,
I plan on
please
it.
do that, bring it up then.
Just, it's out there now.
Yes, sir. Okay. Okay, go ahead.
A question regarding the redevelopment plan 2 at Waterworks Road. I believe those plans were approved in 2022. Where or aware of it, there would be 1,000+ home coming in the neighborhood. And if they are aware of it, have they performed any study for the neighborhood compatibility or any statement regarding the community impact? If those statements or if those studies are available, can you provide it to the community?
Very good question. Not for this board. That's something that, if there's a separate meeting with the administration or reaching out to the.
I mean, they are here right now. Can they answer it?
It's not appropriate before this board. That's what I'm saying. It would be appropriate another, speaking with them separately, because this board is the planning board.
I know this is a public comment period, but it's supposed to be public comment regarding questions to this board, not to administration or the planning department.
See no hands, I'll close the public session. Thank you. Can I get a motion to adjourn? Aye.